Welcome to our discussion on the origins of the US Judiciary. The foundations of the US Judiciary, the branch of government comprising courts and the judges who preside over them, reach back to American colonial history and the early years of the Republic that took shape after the colonies broke with England. The U.S. Constitution created the framework for the judiciary. The structure and the authority of the federal judiciary have evolved further and continuously through compromises forged over the last 200-plus years. SCOTUS stands for Supreme Court of the United States, similar to POTUS, President of the United States, FLOTUS, First Lady of the United States. You will see that referred to a lot in this chapter. During the debates over the ratification of the Constitution, the Anti-Federalists and the Federalists had sparred over what the powers of the new national judiciary should be. Make sure you write down the distinction between the Anti-Federalists and the Federalists having to do with the judiciary. The Anti-Federalists had warned that a too powerful national judiciary would erode states' rights. For their part, the Federalists had contended that a strong national court would be necessary to moderate conflict between the states. Ultimately, the Constitution named the U.S. Supreme Court as the High Court of the land, but the framers intentionally did not make the court's powers specific. Only by saying little about the specific powers of the Supreme Court were they able to reach agreement on the judiciary. One of the most important of the framers' compromises was to establish only one national court, the Supreme Court, and to empower Congress to create all lower national courts. Make sure you write down that Congress has the power to establish lower courts. Congress accordingly set up these inferior courts in the earliest days of its first session when it passed the Judiciary Act of 1789, which created the federal district courts. The federal district courts' geographic jurisdictions matched state boundaries, with at least one federal court in every state. Congress intended that these courts would have strong ties to the states in which they were located and expected that in many cases, federal judges would apply state, not federal law. These federal district courts drew strength from their ties to the states, but the federal judiciary was quite weak, with little authority. Shortly after his election in 1800, President Thomas Jefferson barred the Supreme Court from meeting in the 1801 and 1802 term. Jefferson was concerned about the out-of-power Federalists' potential use of the federal judiciary to maintain control in the national government. Jefferson was perhaps right to worry, because in the following term, in the landmark case Marbury v. Madison, 1803, the Federalist-led Supreme Court grabbed for itself the power of judicial review. Judicial review was the court's authority to review and to strike down laws passed by other branches of the national government. In the Marbury case, the court argued something that had never argued before, that it had the power not only to review acts of Congress and the President, but also to decide whether those laws were consistent with the Constitution, and to strike down those laws that conflicted with constitutional principles. Legal scholar Joel B. Grossman observes that in Marbury, Marshall made it abundantly clear that the meaning of the Constitution was rarely self-contained and obvious that those who interpreted it, a role he staked out for the federal courts, but one that did not reach its full flowering until the mid-20th century, made a difference. Judicial review is the most significant power the Supreme Court exercises. Over time, the court has extended this power to apply not only to acts of Congress and the chief executive, but also to laws passed by state legislatures and executives, as well as to state court rulings. The middle level in the federal court structure, the Court of Appeals, also known as Circuit Courts of Appeals, were created some 100 years after the Marbury decision. Through the Judiciary Act of 1891, this law sought to relieve the heavy caseload that the U.S. Supreme Court faced after Congress had gradually expanded the jurisdiction of the federal courts to include criminal cases during the 19th century. Until the advent of separate circuit courts of appeals, federal district court judges and even Supreme Court justices had needed to ride by horseback around the circuits to hear intermediate-level appeals cases. They sometimes traveled thousands of miles in a year in the practice, which became known as circuit riding. Over time, they began to bitterly bemoan the hardships they faced in serving the geographically expanding country and the increasing case docket. But it took a long time for the states and their representatives in Congress to become convinced of the necessity of courts of appeals, courts that review previous decisions made by courts in the federal or state judicial system. These courts were charged exclusively with reviewing the application of law in previous court decisions rather than reviewing evidence or facts of the cases. The Judiciary Act of 1891 divided the courts of appeals into 9 geographic units, with each unit number corresponding to a circuit. The assumption in carving out these units was that each state would be grouped with states likely to have similar political cultures. Today, there are 12 courts of appeals covering designated regions, and the 13th hears specific kinds of cases, among them cases involving international trade, government contracts, and patents. By creating these separate courts of appeals, Congress significantly reduced the Supreme Court's workload. In 1890, 623 cases were filed with the court. But just 2 years later, after passage of the Judiciary Act, that number fell by more than half to 275. The act also eliminated the requirement of circuit riding, thus easing the burden on Supreme Court on Supreme Court justices. Significantly, in using statutes rooted in the common law tradition, the Congress itself was creating a relatively new form of law, code law, which we will explore more in depth in the next Prezi.